Morning, Maurice. How are you?
Good morning. Good. So I guess we're not going to be doing these pretty soon, huh?
Now, you're the one in the know. I don't know anything. You know, I'm so low.
Well, no, I just heard that the governor is planning on, I guess, rescinding that emergency order that allowed us to do this in the first place in July.
I have not heard any of that. So,
Oh,
you're,
yeah,
like I said, you're ahead of the game. I have no idea.
And supposedly Barbara is working on whether we can still do it by home rule or something.
See how much more in the know you are?
Well, you know, we have three boards and commissions that meet like this, or one, two, actually four. So
It's actually really convenient. And I thought I read that the feds are going to be continuing on like this too. So it'll be interesting.
I love it. I mean, I just,
I'm there with
know,
you.
and even if we stop this, I know for BZA, I'm going to continue to try to at least stream to YouTube because I like the transparency and the fact that people can watch the meetings without even leaving, you know, the comfort of their home. I think that's fantastic.
Now, and then remind me again, originally we were doing certain ones on TV20. Are they played for TV20 at some point, or did we just go all to YouTube? Do you remember?
We just went all to YouTube.
All to
TV20
YouTube.
already was, you know, TV20 is really so
It was
linked up
hard.
with council.
Yeah, I know, with council and then all the other boards and commissions and everything. Yeah. So
Yeah, I mean,
I was wondering about that. So
that was my initial, you know, like, well, let's go to TV20, but
Mhm.
they have too busy of a schedule. So
Yeah.
we're going to try to at least do, because I do BZA.
Yeah.
Yeah, try to keep up with that one.
It'll be interesting. It really will be
Yeah.
interesting.
Yep.
Well,
Well,
I'm going to be muted and not on video, but you know, I'm the least important person here. You're the most important.
yeah, I don't know about that.
You are.
Make it work.
Without you, the WebEx crumbles. Trust me.
Well, thank you.
And I only have my usual whatever it is. I know Fire. Oh, McGowan's on. I know Fire was going to be interested in a couple, and I don't know if
All right. Well, we are having some, I've just been told we're having some technical issues with getting Mr. Bradley on. So I am going
Oh,
to.
that doesn't surprise me. I keep telling him he's got to just have his grandsons there to work with him.
The problem is Carmela will have to postpone if we may not have a quorum if he doesn't get on.
Oh, okay. Somebody's not in today. Yeah. I mean, it's what it is. If we can't get to him, I hear you. It's what it is.
So we're trying right now. I just reset him the link and I'll let you know in a minute.
Sounds good.
Hopefully we'll see him soon. All right, thanks.
Hello.
Hello?
Yes,
We'll be starting shortly. We're just waiting for everyone to get in.
this is Councilman Polensky. I'm here for docket A13-21.
Oh, okay. I will put you
And-
down.
Is there an email or I can send some pictures of this case right here?
Yes, you can send it to me. Or you can just send it to the City Planning Commission. Well, you can just send it to me. You ready?
Who do I?
Robert, can you hear me?
Hello?
Robert, Robert, can you hear me? This is Howard Bradley.
Oh, hi, Howard. This is Maurice. I can hear you.
Okay, I'm here.
Excellent.
Okay.
Carmelo's trying to call me now.
Okay, great. Hold on a second. I'm trying to talk to Councilman Polensky.
Okay, who do I send this to?
Send it to me. So MRUELENS.
E-L, two L's?
No, one L. MRUELENS.
E-M-S.
At, of course, city.cleveland or at clevelandohio.gov.
Wait a minute, city,
No, don't do the city, just at clevelandohio.gov. That's our new domain.
Ohio. Ohio spelled out?
Yes.
Cleveland,
.gov.
Ohio. Okay, I'm sending you this now of this
Okay.
rat. Okay, thank you. Bye.
Sure.
Maurice,
Yes,
is the councilman gonna be on?
Yeah.
I think so. Yeah, he's still on.
Okay.
Yep.
Oh, he's still
He's
on,
just sending-
okay.
He's just sending
Okay.
some additional pictures.
Okay.
Because
He has-
I have to do a Zoom meeting for council. That's why I'm on the phone.
Gotcha.
Okay.
You're
You said docket A13, Councilman?
Yes. Yes.
Carmelo?
Hear you, Mr. Bradley.
I didn't answer your phone call because I got on the line.
I see. I just wanted to make sure you were here.
Okay, I'm here.
Does councilman know that 11/21 has been rescheduled?
Everybody
Okay.
was sent the revised agenda yesterday.
All right.
What councilman is inquiring about it?
Mike,
Councilman Kalinsik.
I'm here for 8/13/21.
okay, that's good. Do we have Maskey on?
Yes, I see him on.
Okay.
I haven't gotten anything yet, Councilman. Do you have Carmela Davis's email?
I'm sending it to you right now.
Oh, okay, great. I'll let you know if I get it.
Okay. ELEMS at Cleveland. Cleveland. Ohio. Okay.
Oh, sorry, I just realized I didn't share the screen. There we go. All
Okay.
kinds of technical glitches this morning.
Okay, do we have Miss Austin on also?
You mean me, Patty?
Yeah,
Yes.
I mean you.
Austin.
Aston.
Okay.
I'm here.
All right. And we have Mr. Vanover, right?
I see Vanover, yes.
Okay.
Yeah, I'm here.
Good. Okay.
Maurice, I'm about to call you real quick.
On the phone? Sure. You have my number, right? Hello?
Maurice, I sent that to you.
Okay, hasn't come through yet. Sometimes it takes a couple minutes.
Okay. You're supposed to spell out Ohio or OH.
Yeah, it's Ohio, OHIO. Cleveland, Ohio, one word.gov is our email domain.
That's what I said.
Okay.
OH.
Carmelo?
Give us one more minute. Councilman is the very first docket for the property located at 14620 Lakeshore. So Maurice is still working on trying to get those pictures that he's trying to send through.
Okay.
Yeah, nothing's come through yet.
Okay, I put it FRUELEMS at
And-
Cleveland.
MRUELENS.
N is in Nick or M is in Mike.
N as in no.
Okay, well, take that. Okay.
Sorry, it's a difficult name to spell. Everybody has trouble with it.
UCLEMS.
So wait, Dennis Bottega is having issues with getting into. 1 second.
Oh, good idea. Carmela just sent you an email with my email address on. I should have just sent you an email, although I don't have your email.
You sent it to my city cell phone?
She sent it to clevelandcitycouncil.org, an email. That has my email address in it too.
Okay.
In case you, just to double check that you got the right one.
Gotcha. Okay.
Good thinking, Carmela. You're on the ball this morning. I'm not.
That's all right.
Chica, I sent one to, I thought I sent one to her as well too, but we'll see what happens here because, this is, okay. But you can start the meeting. Don't hold it up for me. I'm going to comment anyway. Please.
That's just as good. Okay. All right, Carmelo, then we,
Dennis is not, we still have a problem with our board member, our
okay.
board
All right.
employers logging in.
Okay.
So
All
I'm
right,
still
we'll
working
wait.
out that technical difficulties right there. So give me
Okay.
one more second.
This is not our morning. I
Did you get
logged
it?
in. I
Were you
logged
able
in
to-
this morning and YouTube is blocked. It's like,
Wow.
If you're a calling user, I have 3 calling users. I need you to state your name. If you're called
Hi,
in on the
Carmela.
phone. Okay, go ahead.
Hi, Carmela. This is Dennis Mateka. I finally got in by phone.
Okay, so we have
Thanks.
Dennis on the phone. And who else is a calling user who's not using video feed? Please state your name.
James Dorn for Christiana Elridge.
And what is your relationship? That's docket A1221. What's your relationship?
I'm the attorney for Christiana Elridge.
Okay, thank you. And was the councilman the other calling user?
Carmelo, this is Lieutenant Alexiak of Cleveland Fire. I'm not a Colin, but I'm sharing the screen with Inspector McGowan from Cleveland Fire.
Okay, but none of you guys called in on the phone, correct?
Correct.
All right. So I have one more calling user that has not identified themselves.
Could
All
that
right,
be,
Mr. Gallagher, we can go ahead and start. We have all the parties here. Maurice, have you received the PowerPoint presentation or the pictures yet?
not yet.
Not yet.
I haven't received the email from him as
We can
well.
start. We can.
okay, Councilman can, he can comment.
But
Okay. We do have pictures for the property as well submitted by Building and Housing.
Okay, we'll get started. Cleveland Board of Building Standards and Appeals is now in session. I'll read the preamble. In compliance with notification requirements of Ohio's open meeting law under COVID-19 emergency declaration, notice of this meeting has been publicly posted. All boards and commissions under the purview of the City Planning Department conducts its meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record prior to the taking of any vote. In order to ensure that everyone participating in the meeting have the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile version and activated by clicking the hand icon. Please wait for the chair or facilitator to recognize you. Be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also be utilizing the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located on the bottom of the WebEx screen. Next page. Okay, all meeting activity is being recorded by way of the WebEx platform. These proceedings are also being live streamed by way of YouTube. We have provided a link to the meeting for those who wish to speak on a particular case by way of our website and email. We have also received emails from those who have provided written comment on a particular matter. Okay, let's see. We do have, we only have 3 of members of the board that are on, so we have a quorum, but we have to be unanimous in our decisions. I think, I'm not sure, and Ms. Austin can enlighten me on this, but if we're not, if you want to opt out from that, I think you need to do so ahead of time. But that's those are, so we have to be unanimous. We usually are, but I'm just stating that as a fact. Do you have any comments, Ms. Austin?
Do you want to call the roll or do you want me to go now?
I'll call the roll. Go ahead, Carmelo.
Mr. Maskey,
Here.
Mr. Bradley,
Here?
Mr. Gallagher.
Here.
We do have a quorum.
Thank you, Mr. Gallagher. As you stated, the warning, and I would defer to your counsel, Mr. Mateka, but you did give the warning that somebody wants to proceed with just 3. If it is a split decision, the underlying decision of the administrative department is upheld. They do have the right prior to having the hearing proceed to ask for a continuance based upon the 3-member quorum as such. I'd like to ask to verify that the matter is being currently live streamed.
Yes, it is being live streamed.
Thank you. And as we usually do each time, based upon the Supreme Court posting to its website of virtual hearings, the city does object to the use of the chat function. Thank you, Mr. Chairman.
Okay.
And I just wanted to let Councilman Polensek know that I did just get a picture.
Thank you very much.
Okay, with that, we'll call the first docket A1321 14620 Lakeshore Boulevard.
Application and fees are in order. Notice of violation is condemnation of the main structure issued on February 28, 2020. Appeal statement received February 15, 2021, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Building and Housing, Patricia Ashton Law. With the owner or the representative for the owner, please state your name for the record.
Okay, those on this, we need you to state your name before we swear you in.
We have a Christopher, I don't know how to pronounce the last name, raise his hand.
Christopher Bew, Vice President of the Management Group.
Okay,
Good morning, everybody.
morning. Do we
And
have
what is your
anybody else?
relationship to the party? To the properties of Christopher?
I couldn't hear you, sorry.
What's your relationship to the property?
I'm the Vice President of the owner of the property. Yeah, of the business, the property.
This is Patty. Can I ask what that business name is?
G3 Management Group, LLC.
Thank you.
And I also see Anissa Short. Can you unmute your mic, please?
Yes, I'm here. Can you hear me?
We can barely hear you. Ms. Short, can you hear us?
Yes, I can.
Gonna have to turn up his volume.
We can swear him in.
Okay. All right. Solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Yes.
Okay. Councilman Polensik, do you wish to speak now or at the end or sometime in between?
At the end, I'll wait to hear the appellants.
Okay. So let's hear from the appellant. Who's ever going to speak on the project?
Are you able to hear me clear?
You're very, very
It's
low.
very, very low.
Ms. Short, do you have the number to call in?
Ms. Aston just raised her hand.
Go ahead.
Yes, I was going to ask if that was what Carmela just stated, so.
Yeah, she could call in. That would be a big help. We can hear her then.
And Christopher has just raised his hand.
Okay, go ahead.
Okay. We received the violations in February. We purchased the property back in October, I believe we closed. At the time, we didn't have any notice of the violation. We didn't know of any violations. So when we received the not violation notice, that's when we started to take action, because we didn't know we had to take any action before then. So right now we're looking for contractors, and we're trying to get the permit pulled. And we also looking for signs at the moment. So that's what we're planning to do with the property. I don't know. Have any questions?
All right. Well, we're going to hear from the city, from Mr. Vanover.
And sorry, but we were trying to see if we can request a little bit more time, being that we just found out in February about the violations.
Okay. All right, Mr. Vanover.
Good morning. So the property was, there was a certificate of disclosure issued as part of this purchase from, in October 21st of 2020. It indicates on the certificate of disclosure that the property was condemned and when it was condemned. So the purchaser was notified of the condemnation and the violations as part of the purchase.
So the requirement right now, because it is condemned, of course, is that it's got to be all brought up. Correct?
Correct. So I will, as I always do, I will state that regardless of so there was a certificate of disclosure issued notifying the purchaser that the property is condemned. There's obvious violations with the structure, and the condition of the structure alone obviously influences the purchase price. So if the expectation was for this to be a development property, we are now, they've owned it for 5 months, which isn't, well, almost 7 months now. It's not an exuberant amount of time. How much time are they requesting, Mr. Chairman, to the appellant?
Yeah, Christopher has his hand raised and so does Mr. Maschke.
Okay, well, let's hear from Mr. Maschke for just a moment here.
Thank you, Mr. Chairman. Mr. Chairman, to the appellant, have you engaged in a professional architect or engineer to prepare drawings and submit to the city for permits yet?
No, we're looking for, we're actually looking for everybody to pull the permits as far as the electrical, and the building permits and everything else that we need.
Well, it's my understanding, based on the condemnation in this building, that you're going to require architectural and engineering drawings to be submitted for review from the building department first before you can start work. Am I correct, Mr. Vanover?
So, Mr. Chairman and Mr. Maschke, this is a commercial property. It's 4 suites. So it will require architectural quality drawings. It will require design documents of some sort to replace it and to bring it back up to code. Those will have to be submitted to the Department of Building and Housing for review and approval. And that's, so yes, we will require drawings.
Thank you. Mr. Chairman, again to the appellant, do you have the funds to complete this project?
Sorry about gonna ask you a question. But we didn't receive the certificate of disposition from the title company. We received the certificate of disposition first time ever in February. That's the first time us ever seeing anything.
That wasn't my question. Do you have the money to do this work?
We're looking on forward to take out a loan to complete the work.
Okay. Based on what I'm hearing, Mr. Chairman, I motion that we remand this to the city. Do not give any more time, and the appellant can work with the city to bring this building out of condemnation.
Well, okay, I certainly would agree with you. Let's hear from the councilman to see what his view is on this, and then we'll move on with it. Okay, Councilman?
Yes, Mr. Chairman and board members and Madam Secretary, and to the appellant as well. This has been a property that has been a cancer on our community. If you see the picture that I sent over this morning, no effort to secure the building. The grass has not been cut. The backyard is a jungle. I mean, total disrespect for the neighbor. This is on Lakeshore Boulevard, a prominent street in our community. This is a great neighborhood. We have complained about this building for I don't know how long. That building, if you can see the pictures that I sent over to Maurice, that building has been wide open to the elements like it is for years. That building has been in that condition for years. But so the appellant buys the building, and again, I concur, there was a certificate of disclosure, and what he should be doing is going after the title company or his real estate company if he felt that he had been misled or given false information. But I'm sick of looking at this mess. The neighborhood's sick of it, and he can't even cut the freaking grass. The grass, look at how high the grass is. No effort at all to maintain this structure. Outrageous. I'm moving. I'm going to do everything I can to get this building torn down. I'm sick of looking at it. The neighbors next door are afraid in the apartment building, the well-maintained apartment building right next door. I've got kids over there. This is outrageous what has gone on here on Lakeshore Boulevard, right up the street from St. Jerome's Church and a daycare. There's no excuse for this. I'm done with these LLCs that are proliferating our neighborhoods, buying these properties, and letting them sit in this condition. We've got to send a message. No, we're not going to tolerate this crap anymore.
Okay, thank you, Mr. Councilman.
Can everybody see the picture that the councilman sent?
Yes.
Yes.
Okay, just wanted to verify.
Yep. Yes, we've seen the inside, the outside, and like I said, I agree with Mr. Maskey. I think that because there isn't any plan just yet forwarded by the company to go ahead and do something with this, they're still looking. I think that we're going to remand this back over to the city and let them work with you and see what you come up with. But we're going to put them in charge to get things moving on this one way or the other.
Mr. Chairman.
So,
Mr.
yes.
Chairman, we did have Christopher with his hand raised and Anissa Short with her hand raised as well.
Okay, go ahead with Mr. Christopher.
First of all, I just want to apologize because I understand you guys may be frustrated. This has been a problem that's going on in the community for a few years. Like I said, my apologies, but we just recently acquired the property. We're new to real estate, so I don't believe that we should bear all of these years of this frustration that you guys are sending away, because we are actually trying to work with you guys. We received the violation notice for the first time in February, and now we're trying to take the steps we need forward. We are not
Mr. Chairman,
LLC, so just want to let you know.
Yeah, Mr. Vanover.
So, Mr. Chairman, to the appellate, I understand that, and I understand being new to real estate. This is a substantial structure, and my counsel's probably this is not the best one to have started with, or been in your first your first group of properties. That being said, I've asked twice and still haven't received an answer of how much time is actually being requested.
Mr. Christopher.
Good morning.
Mr. Bew, how much time through the chairman is being requested?
Can we get an additional 6 months, please?
Hop in and gonna get rid of it. The walleye, all the things.
Chairman.
Go ahead.
Mr. Chairman, we don't, the city would request if 6 months is given, then 60 days is required for permits to be submitted. So 2 months for
Mr. Chairman,
plans, and then 6 months to be.
Mr. Chairman, to the city, my concern is if this is their first property, this is a very difficult property to turn around if you've never done a project before. And I would be concerned that there has not been an initiative to bring on a professional to help them with documents and submittals, or to coordinate any construction at this point. I have a feeling if we do not remand this back and they work directly with strong oversight from the city, they're going to be back on our docket in 60 days asking for more time.
I totally agree. Mr. Maskey, go ahead and make the motion.
One second, Mr. Chairman.
Oh, yeah, we do have Ms. Short. I'm sorry.
And also Ms. Aston.
Okay. Ms. Short.
I'm
hoping we can hear her. Is she still there?
Yes, can you hear me?
Yes.
Is that much better?
Yes.
All right, awesome. So, again, like my colleague has stated, that we apologize for, not being able to stay on top of the building. However, like he stated, we received this information later on, not knowing that we were under this strain of time, and that it was such an eyesore for the community. Now, we did work with, we called around and we contacted a couple of people in regards to making repairs and pulling the permits and everything, but we didn't know the steps. So we thought that this would be the first place to start, as opposed to going forward and doing so much before we get an answer from you guys. So because of the fact that when we received the documentation stating that it had so many violations, and it said we had 30 days. So this is why we started here. So
Okay.
I would like to know, if you remanded to the city, what is the process after that? What do we need to do, and how would they be helping us with this process? Because that's
Okay.
basically what we're asking for, assistance.
Okay, Ms. Short. Yes, of course, the city would work with you. You can submit to them the drawings and the things that Mr. Maskey had mentioned in the beginning. And so you can proceed. It doesn't stop you from proceeding, but what it does is it tells, you know, you're going to have to work with them and make progress and turn everything into them in order to proceed. And at any time, you know, they could say, okay, you're not doing what you said you're going to be doing, and they have the authority over it. So, but yes, you
Mr.
can
Chairman?
proceed. Yes, go ahead, Mr. Vanover.
Chairman, if I could, I would like to clear something up, because I'm not clear what the term "the city will work with you" actually means. The city Department of Building and Housing has issued violation notices on the property, stating that it is condemned. Nobody has contested the condemnation, so the condemnation stands. What the city will do, specifically the Department of Building and Housing, is we will await their contractors and their design professional to submit plans to us. And we will review those plans, and we will approve the permits, or we will adjudicate the plans, and they will have to fix them. And on a parallel path, the notice of violation still stands, and submitting for a permit and submitting plans does not stay our enforcement on the violation notice, which could be prosecution, could be demolition, or could be any other number of administrative remedies. Simply applying for the permit doesn't stop us from acting on the condemnation if it's not moving. So I want to make sure that we are not a consultant for the property owner. We are a regulatory body whose job is to review plans and to issue permits and to conduct inspections. As long as those things are moving forward, then that has a determination on what we do administratively for the violation notice. That's what we mean by work with them.
Exactly. Very well
Mr.
put, Mr. Vanover.
Mr. Chairman, we still had Miss Aston and also Christopher with their hand raised.
Okay, let's do Ms. Aston.
Thank you, Mr. Chairman. As Mr. Vanover stated, the city cannot consult because they are the regulatory body. But in addition, as Mr. Vanover previously said, if this board wants to give tight deadlines, you all can also state failure to meet those timelines does not give them the remaining timelines. So if you gave them shortened timelines, you can give that failure to meet language as you have in the past at your discretion. But I would defer to Mr. Vanover on the city's position. Thank you.
Okay, Mr. Bew?
You're muted, sir.
I didn't have my hand raised. That was sorry.
Still muted.
So at this point, Mr. Chairman, I would ask that the board make a motion.
Okay, all right.
Made a motion.
Okay, we got a motion out there to remand it back to the city. Mr. Bradley?
Yes.
Okay, so we got a motion and a second. You want to call the roll?
I'm sorry,
Carmelo?
it's the motion is to remand the property?
Yes.
Correct.
Motion by
Okay.
Mr. Maskey, second by Mr. Bradley.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Gallagher,
Yes. Okay. We'll call the next docket.
May I just ask that if you're not speaking, please mute your microphone. We appear to be hearing a Nintendo game or some kind of game in the background. It's very distracting. Thank you.
Okay, we call the next docket is A 921-5103 Gifford Avenue.
application and fees are in order. Notice of violation is exterior maintenance, issued December 16, 2020. Appeal statement received February 24th, 2021, asking until April of 2021 to abate the violations. For the hearing, Tom Vanover, Building and Housing, Patricia Ashton, Law. With the appellants, for the owner for this property, please state your name for the record.
We have a Therese with her hand raised.
Yes,
I do.
Teresa Manos.
Okay, let me go over to where you're at. There you are. Okay. All right, so we're gonna go ahead and swear you in now.
Okay.
Okay, so solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I
I
do.
do.
Okay. We'll go ahead, give us what you're planning on doing.
We have hired a company. I'm still waiting to find out when they're gonna put us on the docket. So he hasn't gotten back to me yet. We're gonna repair the driveway.
Okay, so this is notice for the driveway. Mr.
Yes.
Vandler?
Mr. Chairman, is that bear with me for just a moment. Mr. Chairman, is this owner occupied?
No, it is not.
Okay, so this is a rental property. So what is there's no date. What was your date? What is your request? I mean, the request was to April 2021. I don't object to April 2021.
Yeah, right.
Because we're now almost in June. So the question is what is the request? What is the requested timeframe?
I guess 30 days. I'm not sure. We just met
Mr.
with the
Chairman, to
guy
the
about 2
appellant.
weeks ago.
You have a contract with the contractor.
Yes, I'm sorry?
You have a contract with the contractor?
I don't have anything in writing. It's just all been through text messages. But we met with him at the end of April. And I'm just waiting to hear when he's gonna put us on his schedule.
Look, Mr. Chairman, we don't object to a July 1st date. It sounds like it's forthcoming. I will make
Yes,
the
it is.
statement that as a rental property, as an investment property, it is the responsibility that these things are maintained and managed prior to the city getting involved. We should not be required to tell people to maintain their property. That being said, we don't object to a July 1st date.
Okay, motion is in order for July 1st, 2021. Mr. Maskey?
Move.
Okay, Mr. Bradley?
Second.
Second. Okay, call the roll.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Gallagher.
Yes, thank you. Okay, you're all set.
I get to go?
Yes, you're good.
Oh, okay, thank you.
Excuse me, guys, I had a question.
Pardon?
I had a question regarding the decision for Lakeshore. The property being remanded, does that allow us to have the 2 to 3 to get the available permits needed?
You'll be
Yes.
getting a notice in the mail, yes.
Excuse me?
Nothing prohibits you from getting your permits.
Okay, so we still have to make the changes. Okay, thank you. Have a good day.
Okay. Next docket, 8/12/21, 15117 Ohio Avenue.
Application and fees are in order. Notice of violation is a condemnation of the main structure issued February 10th, 2021. Appeal statement received March 11th, 2021, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Building and Housing, Patricia Ashton, Law. With the appellants, please state your name for the record.
Christiana Elridge, owner.
Okay. Solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Okay. Let's hear from the appellant and find out, Ms. Eldridge, what your plans are.
James Dorrance here also as well, the attorney for Christiana Elridge.
Okay. Who's going to speak?
I could start. This property, we it's been the subject of foreclosure litigation, and we were in the process of attempting to do a short sale, and there was a buyer. However, that short sale did fall through as a result of some closing costs and approval of closing costs, but. After that, we did receive the notice in regards to the violations and the nuisance. We requested, time to be able to go through and look into repairing or correcting the issues. The issues are, correcting the issues would have been, financially prohibitive. So as a result, we've secured a demolition company, Eric Bauer is the excavating doctor LLC. He has applied for permits for the demolition of the home a few weeks ago, waiting for, I just spoke to him this morning. He did indicate that he is just waiting to hear back from the city office. He's going to stop in there today and either get the permits or get an update on the status of the permit. We want to demolish the property and resolve the issues with the property. We're asking for 120 days to get the matter resolved. Didn't realize that the process of obtaining a demolition company was going to take an extensive period of time, but it was quite an effort to go through and get get various quotes and get secure a demolition company and get to this point. But now moving forward, I believe that it's going to be a more expeditious process.
Okay, Mr. Vanover?
Mr. Chairman, there is no record of a permit application on this property. So it's at the address of 15117 Ohio. There is no record of a demolition permit. The last permit was pulled was in September of 2020 when the city boarded it up. So I would encourage the appellant to make contact again with the demolition contractor, because he can't pop into City Hall because the building's still closed. Two, he can't inquire into the status of a permit that he hasn't applied for yet.
Okay, so time-wise, it sounds like an August 1st would do the trick.
Well, Mr. Chairman, if the intention is to demolish the property, then that's great. That abates the nuisance. We would ask that you remand it back to the Department of Building and Housing, because as of right now, there's no permit application. There's been nothing done other than an attempt to sell it prior to the violation notice being issued. So
Okay.
they can continue along that path and do what they need to do to get it demolished. But we ask that you remand it back to us.
Okay, well, that'll take care of it, that's for sure. Any comments?
I concur with the
I would
city.
ask maybe for additional time. I mean, is that someone was saying August 1st date would do the trick. My only concern is just with I know that things are opening back up with the coronavirus situation, but things just still seem to be taking a little bit longer. I was looking at maybe a September 26th date.
Well, what we're finding is that, yeah, there's a lot of people that have been having a lot of repairs and things done all through the COVID part of this. I will say that because your request is that you want to demo it, that the only difference is that would be what the city would probably want to do too, is that they would want to get rid of the eyesore. And so either way, if we remand it back to the city, you'll just get a hold of your guy and tell him to do it. And the city would rather have you do it. And it's going to be cheaper, a little bit cheaper if you do it, and get rid of the nuisance. And that's basically, we get to the same place, only they know that it isn't going to linger around and sit there for months. It can get done. So I think that staying on track, I would agree with the city that we just remand it. You can still get it done. Not a problem. It sounds like you have somebody lined up. You just get the permit out and get it done. Mr. Maskey?
No problem. Now, how does that impact the date? Like, for example, if it gets sent back to the city, what's the timeline that the city? Who do we follow up with the city to get on the same page with regards to a timeline for us to get it done ourselves?
Apply for the permit.
Yeah, the notice of violation, Mr. Chairman, the notice of violation was issued by an inspector, and that inspector can be contacted. And I will just to correct, our record. There is no pandemic delays at the Department of Building and Housing. It's not taking longer to get a demolition permit reviewed. So that's just not accurate. We don't have a demolition permit from the contractor, so we can't review what's not here. So that connection gets made with the inspector first, making the inspector aware that, you're applying for the permit. But if the permit application is not received timely, then the city will continue its process and move toward demolition of the property or prosecution of the
And then
owner.
how long? What
or
is the
any-
normal process time for? What is the normal process time for a permit to be reviewed? Just
residential demolition permit, the process time is between 5 to 10 business days.
Okay.
Hey, Mr. Maskey?
Yeah, Mr. Chairman, I'd like to make a motion that the violation was properly issued and to remand it back to the city for oversight.
Second?
Second.
Okay, Mr. Bradley. Okay, motion by Mr. Maskey, second by Mr. Bradley. Call the roll, please.
Mr. Maskey,
Yes.
Mr. Bradley, Mr.
Yes.
Gallagher.
Yes. Okay, the next docket is A1621-12401 Griffin Avenue.
Application and fees are in order. Notice of violation is interior and exterior maintenance issued March 9th, 2021. Appeal statement received March 20th, 2021, requesting for time to abate the violations. Present for the hearing, Tom Vanover, Building and Housing, Patricia Ashton, Law. Would the appellant please state their name for the record? It doesn't appear that the appellant is here. The appellant was
Okay.
properly notified.
Okay, solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Preliminarily, Mr. Chairman, this is Patty. Preliminarily, Mr. Chairman, to Ms. Davis. Ms. Davis, does your file indicate that the notice for this WebEx public hearing was returned to the board's file for any reason?
No.
And did you receive any voicemail, email, or any other communication, fax, et cetera, from the appellant regarding this matter?
No.
Thank you. Mr. Chairman, it appears the appellant was properly notified, has not appeared or contacted the board, so you do have the right to proceed. Thank you.
Okay, Mr. Vanover.
Mr. Chairman, Maurice, can you back up one page? Right there. So Mr. Chairman, just as you can see here, there is this is a rental property, and it's an investment property, and I mean, we asked that you remand it back to the department for, you know, further action. I don't know where the appellant is, but you know, these things, as we've said, they should have been corrected prior to our involvement as an investment property.
Okay, there's someone that just joined the meeting. I'm not sure that, I don't recognize the name, so.
Mr. Chairman, we have Carmela with her hand raised.
Okay, go ahead, Carmela.
Mr. Chairman, to Mr. Vanover, review your inspector's report, because from Mr. Davis' report, he said that they were in compliance. So maybe that's why the appellant is not here.
Okay. So that's what. All right. Bear with me a moment. I'm actually looking at the last sent. I'm having trouble bringing it up. Yeah, I'm having my own technical difficulties. Mr. Chairman, that being said, if they are in compliance, then remanding it to the Department of Building and Housing has no risk.
Okay, sounds good.
So we would ask that you did, if you remand it back to the Department of Building and Housing and they are in full compliance, then we'll just close the violation notice and move forward. Because they did not withdraw, is that correct, Ms. Davis?
That is correct. He has not reached out to me and said he withdrew his appeal.
Okay, all right, Mr. Maskey.
Move.
Okay, it's been remanded. Is the motion in there a second, Mr. Bradley?
A second.
Okay, so it's been moved and seconded to remand the property back to the city. Call the roll.
Mr. Maskey? Can you hear me?
He's muted. He's saying yes. I can barely hear him.
You can't hear me?
There you go. Okay.
Okay.
Got it.
Yes.
It's from Nancy.
Mr. Bradley?
Yes.
Mr. Gallagher?
Yes. Okay, so we're going on to the time extension. Docket 14A 1421 1552 Ansel Road.
Application and fees are in order. Notice of violation is a condemnation of the main structure. Issued on December 17, 2019. This is a time extension request. We first heard this docket on September 30th, 2020, under docket A 1420. The motion at that time was to grant the appellate until May 1st, 2021 to abate all violations. Present for the hearing, Tom Vanover, Building and Housing, Patricia Aston Law, Would the appellant or the appellant lawyers please state your name for the record?
Yes, good morning. Dennis Nevar, attorney on behalf of Vesta Lynette LLC. Also with me today to provide testimony is Mr. Lewis Brown with the appellant.
Good morning.
Okay, solemnly swear to tell the whole truth, nothing but the truth, so help you God.
I do.
Yes.
Okay, so go ahead. Let's hear from the appellant who's ever going to speak. It's going to be Mr. Brown or Mr. Never.
I can take this as Lewis Brown. I wanted to first thank everyone for their time this morning. Given the introduction, I think Mr. Navar, I think I can take it from here. As was stated, we were heard in September of last year requesting an extension from the condemnation order. At the time, our plan was to move forward with the demolition of these buildings. Well, let me back up. There were also requests at the time of that hearing that the record should reflect that we board up a garage. This is 1552. We're going to get to the next docket, which is 1568 Ansel Road. But just skipping ahead, there were requests made to board up a garage that is a part of these two properties, as well as remove some paint on the garage. As well as take care of the lawn. We did both of those things immediately. By way of background, you can kind of see in the picture on the far left of the screen, which shows the Lynette building. To the left, you can see Regency Square Apartments, which we own, which sits smack in the middle of 1552 and 1568 Ansel Road. That is fully operating multifamily property that we redeveloped. The city is, that's 1568, the picture that was just shown. We redeveloped that property, Regency Square Apartments, on or about 2013. There are city funds. City is our partner in that property, as well as Ohio Finance Authority. And so we have plans to redevelop both 1552 and 1568, which are the subject of this hearing. As I said, the plan was to raise both of those buildings. We engaged our general contractors based out of Willoughby, Ohio, Maroos Brothers Construction, to be our general contractor, our eyes and ears. They went and received 3 different proposals from local demo contractors. As we began to develop that scope of work and what was going to be best for the demolition, the contractors all wanted to engage environmental testing, which obviously delayed the demolition process, especially given COVID and delays in general. We did do the environmental testing. When those results came back, we were informed that both buildings, both 1552 that you're looking at here and 1568, contain varying amounts of asbestos throughout. We had been informed previously that given the age of the buildings, that specialists did not think that there would be asbestos present. There is, however, asbestos present. We are now working on an abatement plan. We cannot demo the buildings with the presence of asbestos, so now we first have to abate, and then we will demolish. In compliance, both of which will be done in compliance, obviously, with state and local regulations governing both the abatement as well as the demolition. I will say I was listening to some of the earlier hearings where points were brought up about taking care of the property by Councilman Polenzek, who I don't know if he's still on the line. We are in the process of redeveloping, and were selected by the city and the Historic Foundation to redevelop the Longfellow School in Cleveland. We're about to close on that. Worked very closely with Councilman Polenzek on that project, which we're very excited about. Different from what the issues that Councilman Polenzek raised on that earlier property. We use our staff at Regency Square to make sure all of the lawn is taken care of. As you can see, the buildings are secured with plywood. We also use our third-party security company to help patrol not only Regency Square, but also 1552 and 1568. So what we're asking for today, as was stated at the outset, is additional time so that we can address the required abatement of the asbestos, and then from there go forward to the demolition phase of these buildings and carry out our development plan for these. We already have plans, 40% plans developed that have been submitted to both the city as well as the state. And we've been working with Councilman Bashir Jones and having discussions with him regarding that redevelopment plan for these properties. So we are a responsible owner and neighbor in this community. We have plans to redevelop the parcels. As I've said, we've been working with stakeholders both at the state and local level, and we'll continue to do that. And we certainly appreciate the accommodation, hopefully today, of your extending us an additional 180 days to effectuate our abatement and demolition plan. So thank you for your time again, and I'll certainly yield back, and if there are any questions, be happy to answer those.
Okay, Mr. Vanover.
Mr. Chairman, to the appellate, do you have a contractor that's going to do the abatement and the demolition?
Yes, as I stated, we have our general contractor, Marus Brothers Construction, is our general, and we've got 3 proposals, both for demolition and abatement.
Okay. And Mr. Chairman, okay, so you have 3 proposals. Is your expectation to select one of those to move forward soon?
Yes. Yes.
Okay, so the abatement is contrary to, you know, what was explained. The abatement process is part of the demolition process. If the building is coming down, if the entire building is coming down, then the abatement process is incorporated within the demolition permit. But from what I understand, there has not yet been a demolition permit pulled for this property.
That's correct.
So you can't do the abatement without the demolition permit being in place. You obviously can't demolish the building without the permit being in place. I don't, I guess my concern is, I think 180 days is an extended, is more than what's needed to demolish a structure, even a structure of this size, and abate it. However, I would ask that any extension of time require that the permit be pulled within the next 60 to 90 or 30 to 60 days.
Is that doable?
I think 60 is, in terms of the process that you outlined, what has been described to us from means and methods is that the abatement needs to happen first. Now, it may be contained in the same permit, but the abatement itself needs to happen first before the actual demolition will happen. That's the way the scope has been described back to us and the means and methods for doing this properly. And the other thing
that is correct. You must abate, Mr. Chairman, to the appellate, you must abate it before you can demolish it. Those are EPA rules. However, you must have a demolition permit before you can abate it. Those are local authority. Thank you.
I understand the distinction. Thank you. The other thing that has happened, obviously, is the cost. The cost has gone up significantly since we've learned of the environmental issues. And so part of the delay was once we learned of the environmental issues, we needed obviously to start thinking about how that cost was going to be addressed, as you can imagine. As I said, we have the best interests of the community in mind, and ultimately the future residents of this property in mind. We're just simply asking for a little bit more time.
Okay, so Mr. Vanover, you talked about, say, July 31st, that the permitting, everything has to be in place, and a September 30th date to complete the violations. That would be the 120 and the 60 on the getting the permits in.
No objection.
Okay, Mr. Maskey.
Yeah, motion for approval.
Okay. Is there a comment there? No. Okay. Mr. Bradley.
Yes.
Okay, second. Okay.
We do have Miss Davis with her hand raised, sorry.
Okay.
Mr.
ahead.
Gallagher, could you
Yes.
could you repeat those dates for me again?
Sure,
You said
absolutely.
60 days. What's the date? Or are you using 60 days from today's date for the permits?
Right, so I'll give you days. I'll give you July 31st for the permitting and September 30th to complete. Okay, call the roll.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Gallagher.
Yes.
This is
Okay,
Patty,
thank
just
you,
to
gentlemen.
clarify, you mean 2021, sir?
Yes, absolutely. 2021. That's our attorney, dotting the i's and crossing the t's. All right, sounds good. So we're all set there. Now actually, that was for both properties. We didn't open the other one, so we're gonna need to do that quickly and include that in. Docket at A1521, 1568 Ansel Road.
Application and fees are in order. Notice of violation is a condemnation of the main structure issued December 17, 2019. This is a time extension. We originally heard this docket back on September 30, 2020. The motion was granted to give the appellant until May 1st, 2021 to complete abatement of the violations. Present for the hearing, Tom Vanover, Building and Housing. Patricia Ashton Law. With the appellants for the property, please state your name for the record.
Yes, good morning. Dennis Nevar, attorney on behalf of Vesta Corp., 1568 Ansel Road. Also with me today is Mr. Lewis Brown, who can answer any additional questions on this property, which were, I think, thoroughly addressed in the last A1421 docket number. And we request, consistent with A1421, that the July 31st, 2021 date for the demolition permit and the September 30th, 2021 abatement date.
Okay, so
Thank
you're
you.
all sworn in from the first case. I'll just say it again. Solemnly swear to tell the truth, the whole truth, so help you God, and that includes everything you just said. Okay. And Mr. Vanover inclusive. So, and this related to both properties. So if there's no objections, we'll just go ahead and move this to be the same. Any, Mr. Vanover, all the same?
No objections.
Okay. Mr. Maskey?
So moved.
Okay, what do you have, Mr. Bradley?
Second.
Okay, call the roll.
Mr. Maskey,
Yes.
Mr. Bradley,
Yes.
Mr. Gallagher.
Yes. Now we are done.
Thank you.
Thank you again for your time. Appreciate it.
Yes, sir. Okay, docket A 2021 West 25th Street.
Application and fees are in order. This is an adjudication order issued on May 6, 2021. Appellant is requested variance from OBC 106.1.1 and from OBC 108.6.2. Present for the hearing, Tom Vanover, Building and Housing. Christian Ashton Law. We have also two representatives from Fire. I don't see them on here anymore. Are they still present?
I see Thomas McGowan.
Yeah.
There they are.
Okay, so, and the appellants. Please state your name for the record.
Good morning, everybody. This is Mark Panzica from Panzica Construction Company. And also joining me is Mr. James Litwin from Harbor Bay Real Estate Advisor.
Thanks, Mark.
Okay, if I could have everybody solemnly swear to tell the truth, the whole truth, nothing but the truth, so help you God.
I do.
Okay. All right, I guess, is it going to be Mr. Panzica? Who's going to be speaking on behalf of the appellants?
I will start off, and Mr. Litwin will chime in along the way.
Okay.
Okay. So we received a adjudication order relative to two OBC items. They both tie into a request for on-site security during off-construction hours. The next slide lists specifically those requirements given exposed combustible construction above a plane of 40 feet above grade. I'd like to give a little bit of history about this this property. So if we go to the next slide, please. So a little bit of background. This project is a mass timber structure being constructed at the corner of West 25th and Lorraine Avenue. This is a newer building type in the United States, given the fact that it is mass timber and the fact that we have glulam columns and beams and cross-laminated timber plank as a floor structure. Each of these elements that have been designed and constructed have a 2-hour rated design associated with them. So this is not traditional stick frame construction that you would see in a traditional apartment complex or house. So the elements are rated as elements amongst themselves. Next slide, please. As far as our logistics plan and on-site security, the site is fully secured around all sides of the project with 8-foot high fencing. The site is monitored full-time by a camera system called ProVigil. As you can see on the screen, there are 4 locations that are bubbled, and they are strategically located to monitor all sides of the project. Each location has 2 cameras inside of its unit that can be pointed in a direction to capture the most amount of view coming in to detect any type of intruder or movement during the offsite working hours. These units are monitored full-time by security specialists in a remote location. When a detection does go off, an alarm sounds that deters the intruder, and then a call is made to the police department in the event of that the intruder doesn't leave. Next slide, please. This is a little bit of background about what ProVigil is, and I'll point out in the upper right-hand portion of the screen, these systems are used on construction a lot, especially if you can see that wood frame construction project. This is what we feel that this system meets the intent of what the NFPA is intending here, which is having on-site monitoring when we're just doing it through the means of technology, which we feel and also is also a requirement of the builder's risk policy, which, as you can imagine, the builder's risk insurance world is hypersensitive to stick frame construction, although this is a different type of construction given the fact that all the elements are rated amongst themselves and don't need to be encapsulated in other assemblies in order to achieve their rating. But we feel that we're using the technology who is monitored full-time by specialists that are trained to detect types of intrusion and wrongdoing. Next slide, please. These are just some examples of the views of the cameras. This is at one of the locations, so you can see the clarity of the images and the pictures that it's able to take on site. And this is one location given 2 different angles from that location. Next slide, please. And then this is another example of another location. So based on where we see possible intrusion threats, we have put these cameras in locations to detect any type of off hours intrusion. And we feel that the ProVigil system, which has been approved by our builder's risk carrier, and it was actually a requirement, meets the intent of the NFPA code for site security during off working hours. James, do you have anything else you'd like to add?
Yeah, thanks for that, Mark. I guess a couple important things to point out from our standpoint anyway is level 1 is non-combustible, so we have a podium situation. Mark had noted this is not a light frame building, so it's new, I'm sure, to everybody here locally. So new, in fact, that on the builder's risk side of the equation, I think we were somewhere in the neighborhood of 7 times the estimated cost of a traditional policy. They reviewed it extensively, the insurer, and dictated what we should do in terms of protecting the building. In addition to that, I know that Panzica has added doors to the bottom, stairways, so access to the second floor, while certainly not impossible to access, to get there would take a little bit more time. So the combination of the camera picking up the activity at the perimeter, which is very effective, and the slowdown at the stair entry points would certainly give us plenty of time to respond if we had any issues.
Okay. Any other comments from the contractor or owner?
We have Miss Aston.
Okay, Miss Aston, go ahead.
Thank you. Just briefly before anything from either Mr. Vanover or the fire department, there was comments regarding quote unquote monitor full time. I just like clarification. What does full time mean? Is that full time when? If it wasn't a 24/7 statement, that's why I'm asking for clarification. Thank you.
Yes, thank you. The monitoring happens during off working hours. So we set those times with the monitoring company. We're generally working from 6:30 a.m., 7 a.m. until 5 p.m. So the monitoring service kicks on during that time, and we adjust those hours as needed if we have people working longer hours. Like for example, we've amended the surveillance over the holiday weekend to include the holiday on Monday. It's part of the service that this company does.
So I guess
thank you, Mr. Chairman, too. Oh, thank you, Mr. Chairman,
No,
to
no.
the
Go
appellant. Does that mean when you are not actively working, it's always monitored? Is that a fair statement?
Yes.
Yeah, that would be correct. And we have an apartment block off the project, and I could attest, I've received several calls from neighbors with the alarm going off, and I can hear it myself. So anytime they're not on site, the building is alarmed.
Okay, and you're saying it's monitored, which means someone is actually watching the site. Is that correct?
Oh, yes.
It's not
That is
just
correct.
signals, but there is actually someone looking at it. Okay.
That's
All
right.
right.
They Mark, if you could add to this, but they have monitor screens. They look at it, and there's a series of phone calls that get made to people that are on a chain of command, if you will. They have an intruder. They look at the intruder. They assess the situation, and they make phone calls. It happens on a fairly regular basis, actually.
Okay.
Mr. Chairman, if I may, I'd like to set some groundwork for clarity. Allow the Fire Prevention Bureau to speak, and then allow the Panzica folks to then speak again for clarity. This is an adjudication order based on the fact that there are on Chapter 106 of the Building Code requiring specific things in the plans. Unlike most adjudication orders that we see, this isn't specifically an adjudication of the built environment, but safeguards during construction. which the building code does require a plan, and the building code does require, like all other things in building plans, that it to be specific and comply with the codes. So that's where the beginning portion of this presentation, it shows what Harbor Bay and Panzica believe to be compliance with the intent of those portions of the code for safeguards during construction. So just to frame that correctly for the board members and for everyone testifying, this is what we are discussing is specific requirements, and they are requirements under the building code, which makes requirements from the Ohio Fire Code. And the Ohio Fire Code makes specific references to NFPA code, where this requirement lives. So I say all that because the scoping, the mental understanding of what it is we're talking about is important, because it is somewhat different than what we are used to seeing for adjudication orders. That being said, I would like, I think now it's appropriate for fire prevention to pose, their testimony.
Okay, and if these particular provisions, fire code going to give us what they actually say, or is that something that you would
Yes.
do, Tom?
No, yes, this is the fire, Lieutenant Alexiak and McGowan will provide you that information.
Okay, all righty, go ahead and proceed, gentlemen.
Good morning, everybody. Thanks for coming. Thanks for taking the time. I'm Lieutenant Alexiak, the Cleveland Fire Prevention Bureau. Yeah, as Mr. Panzica and Mr. Litton laid out, to their points, we don't have any, we don't debate the ratings of their construction. It's still combustible construction. Security and monitoring, as you laid out, is very good. It's a solid system. However, it's only one of the 5 elements that's called out specifically in NFPA 241, to which we're citing as part of this adjudication. In terms of clarifying that, I believe our adjudication order clarifies that, the chain going from the Ohio Building Code, section 10611, through to the Ohio Fire Code, Ohio Building Code, section 3302, which takes us to the Ohio Fire Code, chapter 33, which references our NFPA 241. 241, back to the point I was just saying, references, why we use that as such a good illustration is because 241, does a good job. This is not unusual. NFPA 241 and chapter 33 of the Ohio Fire Code applies to all construction sites. The issue that has arisen here, the unusual nature of this project is its size and scope of combustible construction. It's a high rise, it's above 40 feet, and therefore that trips the requirement that 241 calls out of manned security. We don't debate the benefits and merits of video surveillance, but again, 241 calls out why, what the issues are and why manned security is required. We're looking at the requirements for guard service should be based on, but it's not just limited to whether you can see what's going on or not. It's based on the hazards at the site, the size of the risk, the difficulty of the firefighting situation. When we get above 40 feet and it's combustible construction and there's a working fire, that is incredibly difficult, and the time delays involved to get to that level, particularly when there is only a dry standpipe in place. There is no wet suppression detection or fire alarm detection. There's no fire alarm system in place. The differences between a security system, say video surveillance, versus a fire alarm system. Fire alarm system is stringent. It's held to National Fire, whether it's a temporary or permanent fire alarm system. There is a standard by which it is held. The time from when notification occurs to when the fire department is being called, there's a time standard that is clearly stated. It's usually about 90 seconds. Security doesn't have that standard. It was stated earlier, there's a chain of phone calls that occurs for a security system. Well, what's the standard for that? Is the neighbor calling to let you know that the site's on fire? I mean, I know that's not the case, but you can see the difference between a security system and a fire alarm. Well, we don't have a fire alarm system. And in the size and scope of this project, man security is that much more relevant, being that it's combustible, the heights involved, the difficulty of fighting a fire if one should occur. And then 241, again, has called this out for some time. This isn't new. It's been around a long time. I mean, since prior to 2013, I think 2010, is that accurate?
Or 13.
So that is our position. Is that clear? Is that clarified?
I'd like to add one more thing. The cameras, as you saw in the pictures that Mr. Litwin shared, they cover the ground floor. There's no cameras up 40 feet in the air. The people that they say are going to be responding is the Cleveland Police.
Yeah, those cameras, we could certainly add.
We have not received any of the information about on March 12th, when I received the plan. The only information we received was site security will be between 3 and 8 p.m. by 8 video cameras. So none of the information about the company that you hired. That didn't say that CPD would be responding. I don't see.
Mr. Chairman, we have Ms. Aston.
Okay, go ahead.
Thank you, Mr. Chairman. Do you have a copy of the NFPA that is being referenced? I know you had mentioned about the requirements, and I believe under the appellant's appeal, when it was the fire citation, they actually, I think they provided the copy, but if you don't have it in front of you, if the fire personnel could read the section to the board that it's being referenced, it might be helpful. Thank you.
I can, yeah. Specifically,
Mr. Chairman, could I make a few comments here?
Okay.
If you could let him speak to the code section first.
Sure, go ahead. Lieutenant.
So the code section to which we're referring is, this is out of NFPA 241, section 7251. Guard service shall be provided where required by the authority having jurisdiction. Where required, buildings with combustible construction exposed during construction or the above grade plane shall be provided with guard service when there are no crews on site.
Mr. Chairman, my point being that I wanted that read into the record, there are a few shalls in there. That's why this board, of course, always has the right upon weighing all the factors, all of the testimony, all the evidence to grant any variances. But I wanted to stress the shalls that were in that. Thank you.
Okay, very good. Okay.
There's a section I'd like to add. There's an explanatory note referenced to explain further on that very section. It's in Appendix A7251. Due to the growing threat of arson, guard service should be provided on major projects even where not required by the authority having jurisdiction. The requirements for guard service also should be based on, but should not be limited to, the hazards at the site, the size of the risk, difficulty of the firefighting situation, the exposure risk, and the physical security at the site.
Okay, I have one question for fire, and that is, what is guard service? Who is that? Who would you say it is? Just someone trained, fire, police? Who would you say guard service is?
Correct. It's explained further in the next section. I'll read that up. NFPA 241 7.2.5.2. Where guard service is provided, the guard shall be trained in all the following: notification procedures that include calling the fire department and management personnel, function and operation of fire protection equipment, familiarization with the fire hazards, use of construction elevators where provided. There's also in the explanatory notes for that section a standard an NFPA standard 601 that defines the role of guard service.
Very good. Okay, we'll go back to, is it Mr. Letman that was giving us the information?
Yeah, well, it's both Mark and I, a couple things.
Okay.
We have certainly been very open and with our communication with PD. In fact, when we started digging a hole in the ground, we brought them on board. So if there's any information that the fire department is not getting, it certainly isn't from our desire not to engage. That being said, as I look at all the sections that are being quoted, I think the fire department pointed out a very important point, which is this is a new type of construction. It is not anticipated in the sections that are being, to my view, in the sections of the code that are being referenced. For instance, the flame spread rate of a mass timber building is dramatically different than a stick frame building. This code is specifically looking at stick frame building. So as far as firefighting goes, the acceleration of a fire in a mass timber building, again, is dramatically different than a stick frame building. So I appreciate the code. It also is far behind the curve of projects that are now being developed using mass timber. And I suspect that there'll be some changes in this. There is nobody more interested in keeping this building safe than we are. We don't want to see an incident. If it's a matter of cameras and vantage points, we could put cameras on every single floor of this building and have coverage that would far exceed the coverage of a single person walking the project. And we are ready, willing, and able to do just that because we actually believe, as all the insurance companies that are out there insuring these buildings, that this process of security is superior than a single person walking on a job of this size with this number of floors. You simply cannot cover the building the way that the cameras are and the way that the cameras can. Mark, I don't know if you've got anything to add to that.
I was just going to say, I mean, we've had a great relationship with Cleveland Fire, and we want to keep that open communication going. So if there's anything that we could do to work collaboratively to address the concern using, like James just said, additional cameras, or if there's other types of electronic monitoring, we feel that the technology base of that could be superior given the fact that human nature has its faults as well. And we think that there's plausible solutions for that, and we welcome and invite that conversation to keep happening so we can refine what the best way is for this building, given the fact that it's a new type of construction in the United States.
Okay, just
Mr. Chairman,
Look,
Mr. Chairman, this is Patty. If I may, real quick, question, Mr. Chairman, to the appellant.
Down the street there.
To the appellant, Mr. Panzica and Mr. Litwin, can you certify in some way or provide information to verify that whatever company or personnel that is being used for the full-time off-hours security meets the training requirements that are cited that were right into the record of NFPA 241 under the section 7.2.5?
I can reach out to the security monitoring service and provide their credentialing.
They haven't told you specifically that they are so certified though, correct? Or trained? It's not certified, I'm sorry. The code requires training.
Correct. Their process is using artificial intelligence recognition, and that's where their specialty is to recognize threats that are coming in, and that is in their literature.
Okay, and Mr. Chairman, I just want to stress the fire's concern over, vertical versus the horizontal site security, because one of the number 4 actually is specific as to the use of construction elevators, which is not remotely capable and obviously the code may be behind as appellant requires, but it is still the code that applies through this project. And one of those concerns is not just necessarily vandals, but other emergencies that might happen at the property, including accessing vertical areas above through those elevators in an immediate situation, as opposed to the delay it's required. Again, this board has every right through the variance powers to do so, but fire has stated it's articulated important reasons why this security is more than just calling the police.
Right, and I think we can see that in the code and what it says itself and what it is current and what we have to deal with currently, although it could change. Where you get all that. You know, the other question is the time that the surveillance isn't on, such as during the day. There isn't any guard service there for that particular time. Not that there could be, but I'm just pointing that out as fire did, that you know, not just the time that you're not there, but it's the time that you are there. And as far as the fire is concerned, I'm sure that it's still combustible, even though it's a 2-hour rating. It's still considered to be combustible. So that's what we're looking at, and I think I'm going to refer to Mr. Maskey to see what he thinks of the situation.
Mr. Chairman, before that, if I could make a couple of statements based on the last comments from both Ms. Aston and from the Panzica team. It's important to understand that there was some things said I just want to clarify for the record, because my expectation is this is not the last building of this type that we will see. This building was approved. It's a new construction type in air quotes, in that it was approved under an alternatively engineered design process through the Department of Building and Housing under with great input from all parties, including fire prevention. As such, because this particular construction type we are ahead of the code, and there will be code changes to allow for this going forward. As such, there are dependencies that are unforeseen, and I expect that this particular one will not be the last one, in that the code has not caught up with the technology nor the use of this construction type in this way. I know that the NFPA 5000 has spoke extensively on this construction type and heights and areas and things of that nature. Now, that being said, this is not a type 5, stick frame toothpick building. It is a heavy timber building. And as you said, the ratings and the combustibility of the components is greatly decreased compared to type 5. However, these requirements are not specific to type 5 construction. They are specific to combustible construction, which means type 5 construction wood frame. It means type 3 construction with masonry walls and wood floors and roof. It also means type 4 construction heavy timber. Those are considered combustible construction types. And then to reiterate what Ms. Aston said, this would be, the expectation would be that if the board we would ask that the board upholds the adjudication order as properly issued, because the code does say what the code says, and that the construction type is combustible construction. So what the board will be considering at this point, and this is just housekeeping, is whether or not to grant a variance to this specific requirement based on this specific construction type. But we would ask first and foremost that the board does uphold that it was properly issued, because this is what the code says. This is what the code requires.
Okay, gotcha.
Mr. Chairman.
Go ahead.
Just a couple observations or questions. First of all, it seems like the fire department and the builder both have the best interests of the project and the city in mind, and I don't think they're too far off. I would like to see them come to some sort of agreement that would satisfy. But in saying that, is it common to have a guard on other projects in the city of Cleveland, and how often is that? That's my first question. And then the second question is, this is not the first building of its kind. It may be the largest of its kind right now, but it's not the first one that has gone up. And what are other communities doing that would satisfy fire departments and other communities going forward? Has anybody looked at that as a best practice?
If I can speak
I
specifically,
can make brief comment on that.
but if I
Sorry.
can.
Who
was that was
speak
speaking?
This is hold on. If this is Tom Vandenberg, to Mr.
Okay, go ahead.
Maskey's point, it is the largest. And prior to the code changes for heavy timber, there are the buildings were limited in height. So this 40-foot mark is uncommon for a building of this construction type, if not unbuilt, because previously type 4 construction limited heights not to 40 feet, but the number of stories kept it to so it is not common for a heavy timber or mass timber or cross laminated timber building to be above 40 feet from grade, although not impossible.
Mr. Chairman, can I make a comment on this?
Yes.
I think the gentleman who asked the question, I missed his name. I'm waiting for it to pop back up. We do have the best interest of the project and the city and of the fire department in mind here, as does the insurance industry. The insurance industry has moved to make it a requirement that projects of this size, this is not me, this is builder's risk policy, requires that buildings of mass timber use electronic monitoring on projects. So from my vantage point, that's a good thing for the city to adopt in general, because there will be more of these projects. And there must be a reason. I've spoken to an agent that sent me a very large bill for this project. But I will tell you that I'm sure there's a dialogue and there's a purpose and a reason why they went to video monitoring above and beyond everything else. So that's the only comment I have. I look to the future, and we certainly are going to be adding cameras to our protocol.
Okay, sounds good. Going back to what Mr. Maskey's question was to fire, what do you guys feel you can live with?
Yeah, to what Mr. Maskey was saying, what's common, manned guard. That's actually common and that's actually speaking with from San Antonio to New York to Florida to Georgia, as well as other parts of Ohio for projects of this scope, utilizing combustible construction. And again, I mentioned earlier, I don't debate at all the merits of security system, and I think Mr. Litwin and Mr. Panzica's points on the benefits of the security cameras are, I don't debate that at all, and I agree with it. And I also agree with the insurance industry's assessment of cameras on a site. However, I would like to note for the record that in speaking with insurance industry individuals on my side, they've always recommended it as an aid, not as a replacement to. Cameras can't see cameras can't smell or hear. And they can't feel heat either. So, and again, to the point that I made previously, security is one of 5 elements called out in NFPA 241. So, we have that part covered, no doubt about it. That's not debated at all. I'm glad it's there. Panzica is actually a great contractor. I'm glad they're building in our city. I want them to keep building. They have some of the best managed job sites that I've witnessed as an inspector. But in this case, what's unusual is we have combustible construction that has gone above 40 feet in height. We have a high rise that's going up. And that is unusual. And on that point, I don't think we're out of line at all. Matter of fact, what we worked with is we're not requiring manned security from day one. We're requiring just when it gets above 40 feet in height, And we had been working with Panzica, as Inspector McGowan called out, I believe it was March of last year. We were making regular visits to the site, bringing forward, even brought myself copies of Chapter 33 out of the Ohio Fire Code to ensure that, they were getting exposed to it early on, because we knew there were going to be variables as the project developed, And then again, like I said, we don't debate merits of security as an aid.
And to the point, you're relying on response from the Cleveland Police Department or the fire department. You don't have somebody on scene that knows how to take the buck hoist up. You don't have anyone on scene that knows the exact status of the firefighting equipment. Right now is a dry standpipe. What floor is it on in stairway B? What floor is it on stairway A? We don't have that on site right now while the building is being built. That's what the guard service is supposed to provide.
And then also to the point, Mr. Litwin made a very good point, as well as Commissioner Vanover, the flame spread, this is unusual. I won't get into the nuances and differences between type 5 versus type 4. They are combustible construction both. But fire load, yeah, the flame spread is considerably different. However, the fire load of that project is significant. We're talking about the amount of combustible. I don't want to know. 2014, Los Angeles found out what a fire load is when their project went up. The flames were as high as the skyscrapers next door. We don't want that occurring in Cleveland.
It melted the building department.
Yeah, it actually melted.
Yeah, that particular fire was a stick frame building again, though. That was not just to be clear. That was
Agreed,
not a
but
mass
the fire
timber
load,
building.
agreed, but the fire load was comparable. That's my point. And it was an arson. So, I mean, if an arsonist wants to start a job, he's going to start a job. We know that from our experience in the Cleveland Fire Department.
So,
Mr. Chairman, to fire, do you have any response to Mr. Maschke's questions regarding other jurisdictions? Have you spoken to anyone else?
There's been no one in the United States of America that have built a building like this at above 40 feet high.
Okay. What you're asking for then is to have the guard service required when the project reaches 40 feet or higher. And you are looking for not just during the hours of operation or whether people there on the job, but you are looking that this guard service be around the clock?
Negative. Only when crews are not on site.
Correct.
Only when crews are not on site. Okay.
Correct.
So when crews are on site, you're not.
they have the ability to notify.
Yeah, during their hours of operation, they follow their typical, they have personnel on site, they have their safety meetings, they have their protocols, chain of notification. We have no issue what goes on, during the day. They've got that.
Okay.
Mr.
All right.
Chairman. Mr. Chairman.
Go ahead.
Based on what I've just heard, and that this is the first of its kind, and it seems like an on-site person is during a limited time, I do not think that we should try to experiment on the first building. I think we should support the fire department. I know it may sound punitive to the builder. I think they have the best intentions going forward, but I think this should be an ongoing conversation for the next one. So maybe we could come to a better understanding of how to handle this going forward. But I just don't think there's enough information to give a variance. And then if something happens, I mean, if you look at the fire that happened at Notre Dame in Paris, they had sensors all over that building and they were ignored and they lost their roof. And they even had someone on site. So I just think we need to be a little more mindful.
Okay. Any more comments?
Can I comment back to that?
Yes.
It is not a small amount of time. If you think about an 8-hour workday versus the other 16 hours that they're not working and then weekends, it's a lot of time. It's not a small task. And I guess to our comment back to the elevator, the guard service is not trained in operating the buckhoist, which is the elevator on the outside. That is, you have to have a special certification for that. So there is no operation of the elevator during off working hours. Just for points of clarification.
Okay, more responses?
Mr. Chairman, I have two points that I need to make because I am the one that issued the plan approval for this project. I will state two things: I disagree that the fire load in this structure and the fire load in the California building fire, the LA, are the same. They are not. Fire load is based on many things. It's not just an amount of wood. So I would disagree that the fire load in those two instances are the same. I would also be hesitant to say that nowhere in the United States have they built this building across laminated timber or heavy timber building more than 40 feet. The code currently allows for a non-sprinkled R use to be 60 feet and a sprinklered of heavy timber construction type, and it allows 85 feet for a sprinklered building. So I don't know of all the times this construction type was used. I know it's not common, but I'm not willing to concede that it has not been done in the country, at least this country. That being said, I don't know that actually changes, any positions. I just wanted to make sure that because I did issue the plan approval for this, that those 2 points are corrected in the record.
Okay.
I just have one final comment on the matter. As far as having a person versus 4 or 8 cameras, I understand that you don't have smoke, but if you have people that are being recorded to the site, those people are seen immediately. You cannot walk down the sidewalk close to the fence without this monitor going off. So we know they're there. And the second we know they're there, phone calls are made. So we actually have right now 4 people on site, if you will, looking at this project, off hours and covering that 16 hours and weekends. And I think a report from the monitoring service could show the number of calls that are made. So we don't think that we're sacrificing anything. In fact, we think we've gone above and beyond with this.
Now, I have to ask you a question here on what happens if you do have a guard inside. Is this monitoring system going to be going off, or are you going to turn the monitoring?
Yes. Yeah. That's a great
monitoring
point.
system on?
Yeah, you can't have it on because the monitoring system is looking for motion. So thank you for pointing that out. That's a very, very important point to make. You cannot do both.
That's right.
So basically, you're going to shut off a system that can see every floor from every angle, and you're going to replace it with an individual who, by the way, if happens to be on the 9th floor, isn't seeing what's going on the first floor.
Mr. Chairman, based on that, I think it compromises the system, and I may change my opinion because one person cannot cover a building as much as the sensors can.
Okay.
That is a fact. That is a fact. And ladies.
Fire.
Sorry, can you clarify for the record what sensors are in place?
So right now we have the 8 camera views that are in place around the perimeter of the site.
So are those sensors or cameras?
They're cameras.
Okay, so we don't have sensors on the building site. We have visual cameras only, correct?
As of right now, that is correct.
Okay, and as all fire stated before, that is an excellent aid in addition to main security for combustible construction above 40 feet.
Might I suggest that we take an opportunity, maybe this is where Mr. Maskey was going to go, is to explore what other either camera views or other detection that could be done through electronic means to supplement the cameras so that the concerns are addressed by fire.
The fire would say, if you're talking about fire protection, fire alarm, or further make the dry system a wet standpipe so water can get there sooner.
Mark, I
Or
would
add
just,
sprinklers.
I would,
You know,
I would
those
just
these are
say,
things that are not, that we have not ordered or required. So I think as a, you know, it's being asked of us, what are we willing to do? Well, we already, I would say we're being pretty agreeable from our standpoint in that we have not required a fire alarm system, a temporary fire alarm system to be in place. We have not required a wet standpipe to be in place. We have not required the sprinklers to be active, as Chapter 33 of the Ohio Fire Code calls out.
This is Patty. Is Mr. Panzeca, are you requesting, were you in your statement, were you requesting to talk to fire and then come back to this board, like pause this hearing, or do you
I
want
was
to
just looking for
conclude this
another
today?
compromise solution for this. I don't know what that request looks like.
So,
and
Mr. Chairman, perhaps.
If I might add, I think we have to come back to the committee. You know, the point that having a guard on site takes out of commission the cameras and the views that we have is going to create a problem for our insurer. It is an absolute requirement that we have on our policy. So I'm going to need time, and I'll act right away. I'm going to need time to run that by them, and perhaps in between, we could do a little bit of research on putting some smoke detection of some type in place and add additional cameras.
So, Mr. Chairman,
point-
it seems to be that perhaps a continuance of this hearing where the CBO Vanover and Fire can get together with the appellants after some research is done, try to discuss what possible compromise solutions, and then maybe come back to this board might be appropriate. It's just a matter of, is that 2 weeks or a 4-week time frame?
Okay, let's check with Carmelo and see what's available.
I have one question. Are we saying that these cameras will be set off when somebody's above the second floor of the building?
Well, is that where the guard would be?
The cameras are located along the perimeter at grade level.
Correct. So if somebody's on, let's say, 40 feet or above, let's say the third floor and above, patrolling the building, will he set off those cameras?
If they stick their head anywhere near a window where movement can be seen, that alarm is going to go off.
Above 40 feet?
Yeah, I'll get a diagram on this, but I set the alarm off on the 7th floor last night. So I hadn't even thought about it. I got locked in periodically because I'm here after hours. That alarm went off. So, and there was nobody at the perimeter that I could see anyway.
Fire, do you have a problem with coming back and discussing this a little further?
I don't, if we can put a man guard in place in the interim.
No, I don't think, Mr. Chairman, on behalf of the city, the appeal stays the enforcement, so they're not going to have a problem regardless because that's their job. And they have to wait until this board rules.
Okay, so we're gonna, I guess, we're gonna hold until, I guess it's another, is everybody good with that? We're gonna hold for what, 2 weeks or?
I concur. I would give them 2 weeks to come back, Mr. Chairman.
2 weeks? That'll give you enough
In the
time to
interim-
review?
Yes, in the interim, we will start looking at strategies to add cameras as well, because I actually think that's a very good idea. I've talked to Panzeca about that, add additional cameras on the floors. In addition, I've got a subcontractor meeting that's going on right now. I'll talk to my electrical sub to see if there's any way that we could add smoke.
Okay, well, we're gonna bring it back in 2 weeks. And Carmela, be able to do that?
I can tentatively schedule them for 2 weeks, which would be June 9th, unless I hear from Mr. Panzika if something else come up and they need more time.
Okay. All right. So we'll take no action at this particular time for this case, and we're going to call it back in 2 weeks unless we hear different from you.
Mr.
Okay.
Chairman, I would urge that the two parties can work this out prior would be highly,
It'd be bold and better again.
Couldn't agree more. But anyways,
We'll have to do it.
Got the fire.
Okay, very good. Thank you.
Thank
All
you.
right, we're gonna call up the next docket, A2221-9206 Columbia Avenue.
Application and fees are in order. This is an adjudication order dated March 16, 2021. The appellant is requesting a variance from OBC 903.2.8 as well as OBC Table 602, Section 705.5. Present for the hearing, Tom Vanover, Building and Housing, Patricia Ashton Law. Would the appellants please state their name for the record?
Hello, my name is Sonia Pryor Jones.
Hi, good morning. This is Katie VZ Gillette.
Okay. All right. Is that all that's going to be speaking?
Yes.
Okay. All right. Solemnly swear to tell the whole truth, nothing but the truth to help you God.
Yes.
I do.
We got an affirmative on that. Okay, very good. Okay, so let's hear what the plans are.
Okay. Good morning. My name is Katie Gillette. I am an architect with City Architecture. Thank you for hearing us today. We are here seeking an appeal for the Fab House. The project itself is the conversion of a 1908 single-family home in Glenville into a live-work unit. The live component will be contained to the first and second floors, and the work component will be contained to the basement, and that is going to be a digital fabrication lab. We have appeared before the Board of Zoning Appeals to obtain a variance for the change of use for the structure. And we have been working with the Department of Building and Housing to find a path for permitting that will satisfy the life safety concerns of the project, but also allows us to move forward in a fiscally responsible way. So I'm going to hand this over to Sonia Pryor Jones, who is our client. She's going to provide a little bit of context on the project itself and about digital fabrication.
Thank you, Kate. And thank you all. I appreciate the time being here today. I'm really excited about this opportunity for Glenville. I'm from Glenville. We've had support from our councilman Conwell. We have several residents on our advisory board. So a little background on digital fabrication. It is basically using machines and technologies printing that are controlled by a computer through design software to create tangible objects. This particular kind of innovation space, Fab House, can be found in communities all around the world. There are about 2,000 that are specifically a part of the Fab Lab program, MIT, to really support communities worldwide in this technology. And maybe you can forward the slides, please. So this picture gives you a general idea of what a Fab Lab is.
Hold my back.
If you could go to the next slide. These are the questions from Dr. Neil Field and Sherry Lassiter. Next slide. And again, these can be found in communities worldwide. If you can go to the next slide. Next slide. Our goal is to bring this to the Glenville neighborhood specifically and to support the 20,000 residents with learning this technology and these tools so that they can support them with workforce training, education, entrepreneurship, and honestly, the love of learning and having a little fun with technology. If you can go to the slide. To date, we have been working to build capacity in the neighborhood and really partner with several organizations to help us bring the ideas to the neighborhood and start to expose residents. Next slide. Some of that programming to date, thanks to some early fundraising and programming, has included the distribution of PPE to residents in the neighborhood, a socially distanced pop-up event, which you can see in the image there, where we painted a mural on the property as we're waiting for facility plans to move forward. If you can go to the next slide. And this shares with you a little bit about the kind of technology that you can find in a fab lab or innovation space. This is all off-the-shelf safe technology used by people of all ages, in some communities as young as 3 years old. And again, it's technology like 3D printing, laser cutting, digital sewing machines, computers, and design software. Next slide. So this is the property at 9206 Columbia Avenue, as Katie has mentioned. Next slide. And this is our vision for moving the property forward. I think I mentioned as we are preparing for the facilities upgrade, we are using a multifaceted approach around fundraising that's really allowed us to do some of the programming that I mentioned that we've already started in the neighborhood. I'll mention a few more things. We have been able to host 2 high school interns from Glenville and teaching them digital fabrication technology thanks to our partners at ThinkBox. We've been able to distribute PPE for COVID and ongoing with that. And in 2 weeks, we'll be able to host our first camp for middle school students, which will be off-site. So I thank you all for listening, and I'm going to hand it back over to Katie.
Okay, thank you, Sonia. And can you actually provide a little bit of information to the board in terms of the who will be staying here, who will be housed in the sleeping quarters? And
Sure. And so this particular project is focused not only on the technology, but also the expertise of the technology and bringing human capital to the neighborhood that isn't there yet. And so we'll be bringing guests who are experts in digital fabrication technology to stay on the property while they are teaching residents in the neighborhood.
So,
thank
Mr.
you.
Chairman, I'm sorry, this is Tom Vanover, and thank you for that presentation. I want to again add some clarity to what exactly is before us today, and I apologize if you were planning to get to that, but just so that we're framing this in the right context. This was a single family home, and if you could go to the previous slide, Maurice. So if we look at this slide, sections 3 through 8 will be used as they have always been used as a single family home and for the structure. And correct me if my understanding is wrong. So you really have the porch, the living room, the dining room, the kitchen, the bedrooms, and the bathrooms are all going to be used as they have since the house was built, whenever the house was built. What changes in this design is areas 1 and 2 are now commercial uses, and they I believe they exceed the I'm sorry, I'm getting some echo on myself, so it's confusing me. So, they're being converted to a business use, which exceeds the use the allowances in the live work because it's not just the residents that are working in the business spaces. There will also be outside persons, and there will be public, for lack of a better term, invited in, although it may not just be open to the public. It's persons that are not living in the home will be accessing the basement, lab, and the workroom. So therefore, this becomes a commercial property, a commercial structure that does not comply with the requirements that all our uses be sprinklered throughout. So what the board is looking at, what the appellate is looking to do is to sprinkle that section with the limited area sprinkler system for that section that they're changing the use on, but with no construction happening anywhere else in the building. That is a variance request that is required to go through the board for a variance. And we would ask that you uphold the adjudication order as properly issued and then consider the variance upon the merits presented by the applicant.
Okay, with hearing that, let's go back to the let's get to the the applicant and to see what it is that actually looking to get a variance on. So we're back to you again, Ms. Jones or Ms. Gillette.
Sure. Yes. So, that took some of my thunder. No.
I
If you advance to the
apologize.
next slide, it's okay. Yes. So the house itself, or in its current condition, does fall under the Ohio Residential Code currently, but now we are looking, or will be under the OBC, and so we have we will be reclassifying the house as an R2 use group, and also using section 419 in the Ohio Building Code, which is the live work set portion of the code. We're able to navigate some of the a lot of the upgrades that are required to this facility, but we are seeking a variance to fully sprinkler the home itself. I will add that as a safety measure, we are going to be separating the basement from the first floor with a 1 hour separation, and that is not required in section 419. So that is an additional measure that we are taking to offset the need to, or the need to sprinkler the rest of the home. And a lot of this is being done to kind of balance the cost that is going to take to bring this facility up to the current code. So the fire separation is one of the primary measures we'll be taking to increase the safety of the house itself. We'll also be adding hardwired smoke detectors and carbon monoxide detectors. There'll be some accessibility upgrades in compliance with Chapter 34. And then, as we mentioned, we are proposing to sprinkler the basement itself with a limited area sprinkler by upgrading the existing domestic water line. And so there's a diagram on the next slide that shows the area to be sprinklered, although it's relatively straightforward. And then there is an additional item that we are seeking to appeal as well, which, if you flip to the next slide, we are required to fire rate the existing the existing northerly property. Actually, if you go to the next slide, I can just speak to it better. The house itself is situated on a lot. All the houses on the street are 35 feet wide by 94 feet deep. The house itself is about 24 feet wide. So on the next slide, you can see that there's a near zero lot line condition on the northern exposure of the house. So the code requires that is a 1 hour fire rated wall. We are seeking to appeal that again to balance the cost of construction for the house itself, knowing that house is about 10 feet 10 inches from the adjacent house, and that condition where that house is situated on the northerly lot is unlikely to change. There's a driveway in between the two homes, so if that house is modified, it's likely to remain in its current configuration. So there would continue to be a separation between the two structures of nearly 11 feet. So those are the two items that we are seeking to appeal on. I know Sonia can speak to some of the community members that have supported this project in the past. So we're happy to answer any questions that you may have for us this morning.
Okay.
Mr. Chairman, if I may,
Go right ahead. Yes.
if I can speak to the second variance, this is aside from just the cost of what it would cost to do that, there's a technical infeasibility argument. This structure is currently constructed. It's and where it's currently constructed on the property line would prohibit any openings on that side. I would like to point out, and we've had a considerable conversation regarding this, myself and the plans examiner. There is no work happening on the walls, the exterior walls, and as Chapter 34 of the Ohio Building Code, 3404 specifically says that to the extent of the alteration, it's required to come up to the current code, being that there is no alteration of those components. It would not fall in that requirement. However, the change of use is kind of a blanket, like it's like work everywhere at that point. But as far as we've discussed extensively, the risk of that, the portions above grade are going to still remain as if they're a single family residence. So it's no considerable change of use for that portion. And of course, the basement portion is inherently 1 hour rated because A, it's a masonry wall, and B, it's below grade. So that's one of those conditions where we don't object to that variance. It's not something we can approve on its face.
Okay. What about the first part?
We believe, the sprinkler code says when you have people sleeping in a business that you have to put in a sprinkler system. I don't think that it's, and we agree with that. This is, in my understanding is correct, there's one resident that's going to be occupying this home. Is that correct? Or
Yes, it
will
would be
they
one. It
one
would,
at a time?
it would be one at a time.
Okay. So, Mr. Chairman, this is this is unique in that we believe that the risk is increased because of the business use, but not increased beyond something that's reasonable for sprinklering the first floor. I would ask another clarifying question. What is the occupant load of the basement?
You have to unmute.
It's 8.
There you go.
8?
Yep. Yes.
So it's 8 people in the basement, and we would ask one thing. This is the first time I specifically have seen this drawing. We would ask that with the sprinkler, if the variance were to be granted, the sprinklering of the basement would also include the exit stair that gets people from the basement out. At that point, we believe, Mr. Chairman, that that the risks have been mitigated.
Okay. Does Fire want to comment, or are you guys okay?
Now, Fire, Commissioner Vanover hit the points right on the head. We're in agreement with the commissioner.
Okay, so that's what we have to be able to have a variance for the basement, the sprinkled with the egress stairway out of the basement, that to be included. And I see you're shaking. Yes, you're okay with that, Gillette. Okay, and that the 1 hour separation is good. We're gonna go ahead and we're gonna vary that so that it's acceptable, and that would take care of it. Sound good, Mr. Van?
Yes, Mr. Chairman. So moved.
Okay. All right. Okay. Can I get a second on that?
Yeah, I'll make the motion, Mr. Chairman.
Okay, you make the motion, and I'll have Mr. Ray second that motion. Bradley,
He needs to unmute.
he's got
Mr.
unmute.
Bradley, in order to unmute, you'll have to hit *6. And we also had Mr. McGowan had his hand raised again.
Okay.
We were just seconding the
Well,
motion.
before we, Mr. McGowan then. So, okay,
We're good. Fire's good.
um,
Mr. McGowan's
He
good.
seconded. Let's get a comment. He's good. Okay, very good. Okay, call the roll.
Mr. Maskey,
Yes.
Mr. Bradley, Mr. Gallagher.
Yes. Okay. We're all set.
Thank you.
Mr. Chairman,
Got your
discussion?
variance, and we'll put into that.
Mr.
Yes, go ahead.
Mr. Chairman, discussion to Ms. Gillette. So you will revise the plans to include the limited area sprinkler system, the domestic water line sizing, and include the and include that exit stairwell.
Yes, yes, we will.
And then this will be adopted in 2 weeks, and then we can move forward on the application.
Excellent. All right,
And we'll
thank you very much.
And we'll include upholding the adjudication order as properly being issued. Okay.
Thank you.
All right.
Thank you
Yes,
for your
sir.
time.
We'll move on to the next docket A 2321 2901 Euclid Avenue.
Application and fees are in order. This is an adjudication order that was issued April 29, 2021. Appellant is requesting variance from OBC 903.2.8. A little history on this. This was also an adjudication order was issued on this property back in December 8th of 2018. Whereas the adjudication order was heard on March 9th, 2016 as docket A316. The variance was granted with the provisions that the 8th floor egress stairs be fully sprinkled and that the fire alarm system be evaluated by a professional agency and fully operational before occupancy of the 8th floor with the required compliance with the current building codes. Understanding that any future renovations to the lower levels of the building will require compliance with the current building codes. This was approved and adopted on March 23rd, 2016. Present for the hearing, Tom Vanover, Building and Housing, Patricia Ashton Law. With the appellants for this property, please state your name for the record.
My name is Steven Ciceretto. I am the architect for the project.
Will you be the only one speaking?
I am.
Okay, very good. Solemnly swear to tell the truth, the whole, nothing but the truth, so God.
I do.
Okay. All right, go ahead and proceed, Mr. Ciceretto.
Thank you, and thanks for hearing us this morning. As Carmela stated, this project was presented once before, and unfortunately, due to issues with the ownership, the project didn't proceed. So that that variance has expired in the meantime. So now the project is funded and we're ready to go. So this is basically 8-story building that was an old apartment building. The first floor being commercial uses and accessory uses to the residential floors. The floors 2 through 7 are 25 units apiece that are. It was a hotel at one time, and it's now, and in 2008 we converted it to an apartment building. So similar residential uses. The building is not fully sprinkled, but does have a fire pump and fire hose cabinets and an alarm system. And we are now going to finish this upstairs. You can see it in that photograph. That's the penthouse, and that'll be an additional 10 or 11 suites up there, 11 suites up there, 10 one bedroom and 1 2-bedroom apartments. So it's functioned continuously since 2008 as an apartment building. When we last came and presented, as Carmela stated, we felt that Section 34.1.4 dealing with fully sprinkling the building applied, so that we did not have to do that. And we did agree to and thought it was prudent to sprinkle both of the stairways, which enhances all of the life safety issues from all the floors. As people get into those stairs, they would be fire protected with sprinklers, and then updating the alarm system and having that entire system evaluated. At the time, there were several false alarms in the building that were going off, and it's primarily student housing. So we are always battling that aspect of it. However, we request that you consider this the same, even though a few years have passed. The updated codes have not altered any of the mechanical or electrical or architectural requirements for this building. So basically, we're asking for relief from the fully sprinkling of the entire residential building.
Okay, Mr. Vanover?
You're muted.
This is not revisiting a current resolution and variance. There was a resolution and a variance issued previously on a different project altogether, although that project was, by all intents and purposes, the same project. However, that project was not, the permit wasn't issued, or wasn't completed. So this is a new submission and a new adjudication. So that's just a little bit of housekeeping. It's not like an extension or an alteration. I first read it as an alteration to a previously issued variance, and that is not accurate. This is a repeated request for the same variance. My question is, though, I have two questions, Mr. Chairman, to the appellant. Has the fire alarm been reviewed and corrected and repaired as was required in 2016?
I believe that monitoring system has been constantly updated, but it hasn't been fully applied with provisions for the 8th floor at this point, because no work was done up there.
So the request, Mr. Chairman, the request in 2016 was that a full evaluation by a fire protection or alarm designer be completed of the fire alarm to verify any inadequacies or and to correct all the problems that it had in those days. That's my question, not regarding the expansion to the 8th floor.
No,
that's been completed.
We're anticipating that new updated system would be part of this application. So I think they did maintenance on that at that time, Mr. Vanover, but it wasn't professionally done, which is part of what we're requesting that we would do as part of this application.
Okay, and then Mr. Chairman, if you could clarify a statement, you said that it's primarily student housing and that you've been dealing with what that, the issues or whatever that means. Can you clarify what that means?
Yeah, students and people triggering false alarms, pulling the alarm.
That's kind of what I thought. I will point out for the board, though, Mr. Chairman, this is your client base, and this is what fills the building. So, unfortunately, all uses and specific client bases have their own hardships. And then finally, I'll just make for the record that because of the expansion and the additional units on top, this does not gain that Chapter 34 it doesn't comply because you're actually expanding it. However, it is not uncommon for us to take an existing building that is residential, that's non-sprinklered, and require that as they get remodeled, that you have to sprinkle the entire building. So any variance granted, we would ask, requires all of the new 8th floor be sprinklered, the egress stairs through all the way to the point of discharge be sprinklered, and that the requirement for the entire building to be sprinklered stands, only that it is not required at this time, that it is still required as it gets remodeled or any new construction in those areas.
That was our understanding.
Okay. So that is your understanding. Okay. And those would be changes that have to be done, plus the upgrade to the fire alarm system?
Correct.
That is correct, Mr. Chairman.
Okay. Okay, fire?
Hi, yeah.
Any comment?
No, Mr. Vanover captured the sprinkler questions and whether or not it was 34 or not. He answered that for us. The fire alarm system, what's the time frame that we're looking at? We're having that resolved, identified in 2016.
They are planning on starting this project. We were adjudicated. We didn't get a final, permit, but pending the permit process, they're hoping to start this in late summer. So that would be a higher project.
Okay, thanks. Fire's good, Mr. Chairman.
Okay, fire is good. So with that, we will take a stab at this. If anyone has, unless somebody else has another comment, we're going to uphold the adjudication order as being properly issued, and that the requirement for the variance is that just the top floor, the new is going to be sprinkled, and the egress out of the building all the way out from top to bottom is to be sprinkled, and that upgrade to that fire alarm system needs to occur also. I guess that's it. The motion is in order.
So moved.
Motion by Mr. Maskey, second, Mr. Bradley.
Discussion?
Okay. Go
I
ahead.
believe, I thought I heard Mr. Vanover state that as the areas were upgraded, they would also be sprinklered. Does that need to be stated, Mr. Vanover, or is the stated variance motion?
It does. No, it does. It does need to be stated in the resolution that
we
all
will
the other areas.
Everybody's on board with that, that any other new work that goes on in any of those areas will need fire alarms, the sprinkler system added to them. So, Mr. Maskey? Okay. All right, so it's moved and seconded. Call the roll, please.
Mr. Maskey,
Yes.
Mr. Bradley, Mr. Gallagher.
Yes. Okay, thank you.
Thank you very much. Appreciate your time this morning.
All righty. Okay, what we have, our next, we're done, huh? Okay, we've got, we don't have any resolutions, right? Carmelo?
No resolutions, just adoption.
So we just need
of the minutes.
approval of minutes, right? Is there any additions or corrections to the minutes?
No.
So moved by Mr. Maskey, second. Mr. Gallagher?
Mr. Maskey,
Yes.
Mr. Bradley, Mr. Gallagher.
Yes. Okay, there's no other business to come before us? Meeting is now adjourned. Okay. Thank you all.
Take care, everybody.
June 9th.
Thanks, everyone.